Hi, I'm Kathryn Turpin, and I want to talk for a few minutes about something that I help my clients with all the time, and that is crafting a letter of intent. So this will be a very basic and general overview of letters of intent and might be of particular interest for someone who is looking to buy or sell a business or is thinking about pursuing a new business relationship with another party. However, I hope that everyone would still find something useful from this video. So first I want to clarify terminology. I use the term letter of intent, but really that is the same thing as a memorandum of understanding or a term sheet. Those three things may come in a different format, maybe a letter form or a chart form, but they are all really the same thing and they serve the same purposes. A letter of intent is most useful when parties are beginning to negotiate a fairly complicated agreement that will take some time to negotiate and finalize. This could include the purchase of a company or making a significant investment in a company and getting management rights in return, or even entering into a strategic cross-marketing or product supply agreement. In these situations, a letter of intent can serve a couple of different purposes. First, it creates the framework for the more detailed negotiations that will follow. And second, it facilitates those negotiations by setting up or imposing some enforceable or binding rules, such as confidentiality. A letter of intent should specify which provisions are binding and which provisions are going to be non-binding. So the binding terms are the terms that will be enforceable against either or both parties, regardless of whether the underlying transaction is completed. And as I mentioned above, confidentiality is a big one. Each party should be confident that if it shares confidential information during negotiations, that information will be maintained as confidential. Another binding term is exclusivity. One or both of the parties may want the other party to stop negotiating or seeking offers from third parties during negotiations. Thirdly, expenses. During the letter of intent stage, each party should bear its own expenses. Of course, the final agreement can provide for some reimbursement of expenses by one party to the other, but the letter of intent stage, each party should bear their own expenses. And lastly, termination. A letter of intent should specify the date by which the letter of intent will terminate if a final agreement has not been signed. Next, a letter of intent will include non-binding terms, and those are all of the business terms that the parties have agreed upon so far. So this would include a general description of the assets being sold or purchased, services to be provided, purchase price, payment terms, management rights. And the reason these terms should be specified to be non-binding is because they may change or they may be adjusted during negotiations. So if you are thinking or looking to buy or sell a business, or considering entering into a pretty complicated transaction with another party, we can help you decide whether a letter of intent would be appropriate for your situation. And if so, we can prepare a letter of intent that would suit the needs of the specific situation and help the negotiations for the underlying transaction go more smoothly. Thank you.